All rise. Court of Appeals Division 1 is now in session.
Morning, please be seated. This is the time set for argument in LOMA MARIPOSA Limited Partnership versus Santa Cruz County, our tax number 17-0001. Each side will have 20 minutes within which to present their argument. Here this morning, appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of the time in that regard. We have read the briefs. We've been through the record. We've conferenced the case, so we're familiar with, I think, with the underlying facts and the issues that you've brought to us today in this matter. We're recording the proceedings both by audio and video. The video will be available on YouTube at some point in the very near future. So if you're really dying to see that, you know where to go. The point here, though, is that as you approach the podium, for those who may want to watch the video or listen to the audio, please identify yourself and your client for us. With that, appellant may proceed.
May it please the court, counsel, my name is Roberta Livesay, and I'm here to represent Santa Cruz County. And I would like to reserve 8 minutes for rebuttal. The entire case that we're here today for arose under the error correction statutes. The tax court ruling needs to be overturned with instructions to grant the county's motion for summary judgment for 3 reasons. The tax court erred on the law, and there is a disputed issue of fact that is material to that court's decision that precludes summary judgment. The consent issue here does not give rise to any error, particularly under the South Point Energy case, because no error actually occurred as that term is defined by the law. And thirdly, the taxpayer waived its right to pursue mandamus relief on the consent issue, and the tax court had no jurisdiction to grant mandamus relief on that issue. The county would like the court to understand that the tax court specifically wrongly held that the notice of claim form, quote, asks for the address of the owner as shown on the tax roll for the year being contested. This is wrong. The tax court actually added the words for the year being contested in its April 11th, 2016 minute entry decision, which is found at Appendix 6 to our opening brief. Appendix 7 to our opening brief is a copy of the taxpayer notice of claim. The only address that that form asked for is the owner's name and address as shown on the tax roll. When the tax court wrote its minute entry, it added for the year being contested and said that the taxpayer filled it out correctly because for the year being contested, its address was the Irving, Texas address, and somehow the county should have known that that was no longer the operative address. But the tax court is just plain wrong. There's no requirement on the form and no requirement in any statute that when a taxpayer submits a notice of claim under the error correction statutes, they use an old address, even if it's been superseded.
If we have a box, a 4B, mail decision 2, what's the point of having that box, if not to direct the county where to send its response?
Well, I think the tax court actually got that part right. The taxpayer, by saying mail decision 2, is willing to accept delivery at that address. But that's not what the statute says. The statute says that the county is supposed to file a written response to the taxpayer. That's in section 42-162-54.c. It doesn't say to the taxpayer at an address that the taxpayer chooses that's not on the form. It's to the taxpayer. And we've provided in our briefs other examples of what, first of all, the Circle K case defines the taxpayer as the one who pays the tax, not the taxpayer's attorney or some designated addressee on a form. So we have to really pay attention to what the law is saying. I think the tax court just got caught up in some of the confusion here that is generated by that. It's a convenience for the taxpayer, but it's not a requirement on the assessor.
So it's okay for the Department of Revenue to mislead the taxpayer and misdirect them to submit the response, or to say that the county's response should be mailed to, or to allow the taxpayer to designate where it's going to go. I mean, that's just wrong, and there's no consequence here.
I think there is a confusion here, but I don't think it's a misleading. I think it is, like, as I said, it's a convenience for the taxpayer, and the taxpayer is bound by that. For instance, attorneys move around all the time, change law firms. If this attorney was no longer at that address, but the denial had been mailed there, the taxpayer is still bound to accept service at that address. But the taxpayer is supposed to put its own address there as well, and the requirement on the taxing authority is to get that notice to the taxpayer. So here this taxpayer is given two addresses, one of which is an active current address on the tax roll, and the assessor mailed the notice to that address chosen by that taxpayer.
I just need to understand this. So you're saying the taxpayer is bound by the consequences of this form, but the county and the Department of Revenue are not?
Not exactly, Your Honor. I'm saying the taxpayer is bound by the consequences of the statute, and the statute directs the taxing authority to file a written response to the taxpayer. That's the plain language of the statute, 16254C.
Are you saying, Ms. Livesay, that in all of the other cases, the taxing authority has mailed the decision not to the address and person identified in box 4B, but rather to the person identified and address shown in box 4A?
If Your Honor is referring to the other cases brought against Santa Cruz County on the same issue of incorrect mailing, no, I'm not saying that. In the other cases, one of which is the subject of a memorandum decision, the county mailed it to an address that had never been on the tax roll and was not on the notice of claim form.
I'm just trying to understand. Maybe there's nothing in the record on this. I'm just trying to understand what it sounds like you're saying is that box 4B, even though it's on the form prescribed by the Department of Revenue and to which the taxpayers are obligated to comply, you're saying it doesn't matter, and that it sounds like the county, as a matter of course, mails the decisions to the person and address identified in 4A, and I'm not sure that's true.
And I can't answer that, Your Honor, because I don't know the answer to that question. What I do know is this: if the taxpayer had left 4B blank, there would be no adverse consequence to the taxpayer as long as it included an address in 4A.
Well, does the statute, it does require that a written response be filed, and you've indicated earlier it doesn't say to what address? Does it say that it must be mailed to the last address on the tax roll?
It just says to the taxpayer. And at the time that this decision was mailed, that's something else I think the court should be aware of. The decision was mailed on January 9th. The address, though, the Irving, Texas address was active for 2011 and 2012 and is shown on the assessor's records as active as of January 1, 2011. Appendix 2 to our opening brief is the property profile for tax year 2013 showing the Fort Worth address, but also indicating that it was active on the same day. So from the tax court's perspective, somehow that indicates that the Fort Worth address is more recent than the Irving, Texas address, but they're both the same day. And then the taxpayer comes along and uses the Irving, Texas address. Use that Irving, Texas address on 2012 December 31st of 2012, and then used that same Irving, Texas address again on May 20th of 2013, well after this dispute had come up, and they were complaining already that the assessor used the Irving, Texas address, but then they use it again on their petition for review to the Board of Equalization.
Can you tell us a little bit about the owner's name and address as shown on tax roll? Who maintains the tax roll? Does the taxpayer have access to that to modify the address? Or how is it, what's the significance of the owner's name on the tax roll?
The owner's name on the tax roll is a phrase that you find on the forms. You don't find it in the law. But as far as procedurally how it works, yes, the property owner can alert the assessor at any time of a change of address. The maintenance of the assessor's records, of course, is up to the assessor to maintain. But the problem here is that we have two different addresses, both active on the same roll, and now we come to a point where the taxpayer is alleging an error which does not come under the definition of an error in the error correction statutes, sends in its form, uses on the form an address that is equally as active as the Fort Worth address. They're both equally active on the same day. Whether there was some kind of error in the record it's showing it as the same day, we don't know, because this case was decided on a motion for summary judgment. So the standard of review is de novo, and all of the facts in this case have to be viewed in the light most favorable to Santa Cruz County. So we've got...
Our review of that, though, is de novo, as you just said. So, yes, I'm not so much concerned about what the tax court did. I'm concerned about what we should do. And I keep focusing on the box 4B, which it seems to me the assessor is asking the taxpayer, to whom should we respond when we file a response, which is kind of goofy because you don't file anything, you just mail it.
Exactly.
That seems to be a critical issue. And why ask for it if the assessor isn't going to commit to mailing it there?
Well, Your Honor, sometimes these claims are resolved in a face-to-face meeting. Taxpayer comes into the assessor's office, meets with the assessor, and the assessor gives him his decision right then and there. If the form was to control, then the assessor could give the taxpayer, hand the taxpayer, his written decision at that meeting, and then later be held to consent it to the error because he didn't mail it to the address in box 4B.
That's not the case here, though.
It is not the case here, but that is a logical extension of the tax court's decision. And here we've got an error that doesn't qualify as an error. We've got a tax year being appealed on a low-income housing tax credit manner that was previously appealed in a prior year, and the statute says you can't bring it up again. But this taxpayer brings it up again anyway, gets denied. The denial is mailed within less than 2 weeks after the claim is filed. And once it's brought to the Board of Supervisors' attention that no decision was made, the statute says the Board of Supervisors is supposed to direct the treasurer to issue a refund. Board of Supervisors didn't do that. The taxpayer here had an absolute right to bring a mandamus action against Santa Cruz County to get them to do a non-discretionary thing, issue a refund. Instead, the taxpayer chose to go to the Board of Equalization, plead its substantive error correction claim, never bring up the so-called consent issue, waives that issue, and then when it loses again at the Board of Equalization, brings this to tax court, which the tax court doesn't even look into what might have actually happened. To answer your questions, Judge Johnson, about who maintains those tax records and how did this happen and what happened, the tax court just adds words to a statute, and to a form, and says the county didn't comply with the words we added to that form, and therefore the county loses. At a minimum, this case should be remanded for findings of fact, bringing out the evidence on those issues. But the county's motion for summary judgment is very clear. There's no error here under South Point. There's no need to go into these other issues because the fundamental issue is no error occurred. And it would be an abuse of the purpose of the property tax system to give a windfall tax refund in this case without even knowing exactly how this came about in the first place.
Did the county argue waiver in its motion for summary judgment?
Oh, yes, Your Honor. We definitely did.
Maybe your colleague can point out where in the record that's found.
It would
Talk
be,
about that. When you get up again.
Okay,
I don't want to take your
thank
time.
Yeah. And I'm happy to answer more questions at this time. Otherwise, I'd like to save the rest of my time for rebuttal.
All right, thank you,
Thank you.
counsel.
Good morning. May it please the court, I'm Douglas John, and I represent LOMA MARIPOSA Limited Partnership. Kind of starting with your last question. The county has raised 4 arguments in this case. I think 2 of them can be dispensed with right away. 2 of them deal with mandamus and waiver. The county did not raise those issues at the trial court level. And this court has consistently declined to consider new arguments on appeal, even when they involve constitutional issues. So we had asked this court to decline to consider these arguments as well. In addition to on the waiver and mandamus argument, the facts in this case are very similar to what they were in the LOMA MARIPOSA 2 case, which this court decided in November of last year. And in those particular instances, this court rejected those arguments there as well. In fact, they found on the waiver issue, quote, the taxpayer's actions do not indicate waiver. Taxpayer's actions in no way convey an express, voluntary, and intentional relinquishment of its right to challenge the county's administration of the error correction statutes. So they didn't raise it. They didn't raise it at the tax court, and again, the facts are pretty similar, and this court has already addressed it. As with regard to the preservation of the consent issue at the administrative hearing, in other words, the county is arguing that we didn't raise the consent issue, and therefore we shouldn't be allowed to pursue it. Again, they didn't raise that issue at the trial court as well. In addition, if they had raised that at the trial court issue, we would have been able to rebut that claim, because we have an audio transcript as well as a written transcript from a transcription services we would have been able to introduce. And what it shows is that, in fact, much of the hearing pertained to the consent issue. And I'm surprised Ms. Livesay doesn't know that, since most of the participants in it from Santa Cruz County participated and they're fully aware of what went on.
Is that a matter of record?
It's not a matter of record because it wasn't raised at the trial court level. My point simply is that if it had been raised, we have evidence, so to speak, that it would have been raised. With respect to the issue of the notice, what Judge Whitten had in front of him to decide what was the most current address was the following. He had the property profiles for 2009. The property profiles are a record from the county assessor's office that is produced, describing what the value is for the particular year. And he had the property profiles for 2009, 10, 11, and 12. Those are the years in which we filed our notice of claim. And what do those property profiles say? They say that the address for those tax years was Irving, Texas. He also has a property profile for 2013. Now, 2013 is actually calendar year 2012. And what does the record show on that? The record shows that the new address is Fort Worth, Texas. So sometime between 2011 and 2012, the address was changed. We don't know how the address was changed or who had changed the address. We submitted a request for production to the county. The county responded and gave us 536 documents related from the property's file. There was a change of address from 2008 in there, showed that somebody initiated the change in 2008. There was no change of address form within the documents that the county submitted to us in our request for production. So you have, for all the years we filed our notice of claim, the address is Irving, Texas. In 2013, which is 2012, the address changes, and it shows Fort Worth, Texas. In addition, again, we filed this on December 31st of 2012, In addition, on February 28, 2013, about 7 weeks later, the county issues its notice of value for the 2014 tax year. What address is on there? The Fort Worth, Texas address. We also included in the record printouts from the county assessor's website showing that for 2013 and 2014, the address was Fort Worth, Texas. This is what Judge Whitten had to examine as to what was the most current address, and he came to the conclusion that Fort Worth, Texas address was the most current address. Now, the county has made a big deal, I guess you could say, of the active on those property profiles, that it was active on. And it says it was that for 2012, the address was active on 1/1/2011.
That's the supposed date that the new address was active on?
Well, for 2012, the records show it was Irving, Texas. And then it says active on January 1 of 2011. For 2013, it shows the Fort Worth, Texas address, and it says active on 1/1/2011. If you go back and look at the 2011 property tax profile, 2011, the year before 2012, it says active on 1/1/2011. What this means, I don't know. The county didn't produce any evidence as to what it does mean. It didn't submit an affidavit from the county assessor's office explaining what it meant. Gave no guidance to the court or anybody, allowed us to rebut anything. They're just claiming that this somehow raises that there's a dispute and there's confusion as to what it means. I don't think it does confuse anything. Judge Whitten looked at what the record said, and he made a clear determination that the most current address was the Fort Worth, Texas address. But that kind of, in a way, shifts the focus of what should be. And I think your questioning picks up on this, which I think was your first question was Section 4B. Why have a Section 4B if the county can pick or choose where it wants to mail its notices? There's also on there, on Section 6, it tells the person who's filling out the form, put their name and address on there. We did that. And so there's a Section 3 is for the situs address or the property, actual physical location of the property. So there's 4 addresses on there. The county picked 4A. What happened is, if you look into the record and cited, I believe, in one of our footnotes, I can't remember which one it was off the top of my head, but what happened is the county assessor employee, one of the supervisors, assigned this to a level staff person. And the staff person took it without, I guess, proper training or knowledge, looked on it, saw 4A, she saw, well, and she mailed it to that address. So the county,
I haven't gone back to look in the record on this, but with these forms that are available online, are there also instructions that go with the forms?
correct.
What do the instructions say about the purpose of Box 4B?
Well, where does the taxpayer want the decisions to be mailed? And another point that you picked up on, which I think is important, is that the legislature, when they wrote the Notice of Claim statute, went out of its way to specifically tell the department to prescribe forms, to create forms. It doesn't do that, to my knowledge. Ms. Livesay has more knowledge than I do, but it doesn't do that in other parts of the taxing statute. But it did it here. Now, why would it do that? Well, because there's the 60-day provision on consent. There's there's deadlines involved in notice of claims, which have big impacts one way or the other. And so I think the legislature wanted to make clear that there was a uniform standard or form for the notice of claim forms. So yes, I think it did. The legislature, of course, didn't come out and say you have to fill out Form 4B. You have to put 4B for a mailing address. But I think the fact that it is in that form, and given that this is a notice of claim, and given that there is a 60-day window in which to file this, or you consent, that it's imperative that the county follow the directions and mail it to the taxpayer's address. And the reason, and it didn't do it here, and that's the reason why we're here. If it had mailed it to our address at our law firm, we wouldn't be before you today.
Is there an argument that knowing the taxpayer is represented by counsel, the assessor needs to respond to the lawyer?
There's no law that says that, but yes, that would make common sense that you would do that as opposed to sending it to the taxpayer. That's the purpose of having a representative, whether it be a lawyer or a tax agent or someone else. That's why they have that there.
I'm trying to understand the purpose of the name and address as shown on tax roll, or maybe just the tax roll. Does the record tell us what other purposes that address may serve? In other words, for example, does the record tell us is that where an assessment is mailed originally? Or?
The record doesn't tell us anything with respect to what the meaning of that is. There's nothing in the record with regard to that. Finally, with respect to the county's assertion that the underlying merits of the notice of claim, or they've attacked the underlying merits of the notice of claim, saying they're not actually errors. We fully discussed that and briefed it, and in our opinion at least showed that we think, yeah, there actually are. But I don't think that matters. Because if you look at the Hormel case, which we discussed in Hormel, the taxpayer filed a notice of claim seeking reclassification as a non-commercial historic property. They go to the meeting with the county, Maricopa County assessor, and at the meeting the county consents and agrees that it should be reclassified. Well, a number of months go by, and the taxpayer contacts the county and says, hey, where's our refund? The county goes, well, we're looking into it. Contact them again. Now the county's changed its position. What the county realized is that they had granted the error correction. They consented to it. But in fact, the taxpayer had no legal basis for doing so. The time had passed for them to file for reclassification. So there was no merit, really, to the taxpayer's claim. So it was the county's position that since the underlying merits of the taxpayer's notice of claim was invalid, therefore its consent was void. And the case was appealed to this court. And the court said no. Said the court rejected that argument and instead held that, quote, once the county assessor reached an agreement with the taxpayer on the merits of the claim, thereby triggering the express provisions of 42-16254C, the consent was unconditional. So all their arguments with respect to whether or not about the underlying merits of the claim, whether it is valid or it's not, as far as we're concerned, is really under the holding in Hormel.
So once there's a consent, whether it's actual or constructive by failing to deliver the denial in time, these jurisdictional arguments are of no effect.
Correct. Yeah. And so we believe that the same reasoning that applied in Hormel would apply to this case. So, again, the county, to briefly summarize, the county did not raise the waiver and mandamus issue below. It did not raise the issue about whether or not we had raised the consent issue below. And I think it's clear that the most current address, as Judge Whitten determined, was the Fort Worth address. And all their other arguments are, in a general sense, addressed by Hormel, but we addressed them specifically as to why they are, in fact, errors. So with that, does the court have any other questions?
No. Thank you,
Okay.
counsel.
Thank you.
Yes, okay, thank you. I've gone through the record below, and I apologize to the court. I thought that I had raised it below, but we did raise it in our opening brief, and appellee responded, did not object to our raising the waiver issue, And the waiver issue here goes directly to the jurisdiction of the tax court. And while I'm very well aware that this court generally will not consider arguments at this level if they were not raised below, that's a generality. This court may consider those arguments. And here it was met with no protest in the response brief that was filed. The reason it goes to jurisdiction is because the consent issue was not raised at the Board of Equalization. And this appeal to the tax courts, not denominated as an appeal, can only look at issues that were raised at the Board of Equalization level.
Now, we've just heard an avowal by counsel that it was raised the Board of Equalization, and that I think what his point is, if you'd raised it in the trial court, he would have supplemented with that record.
He doesn't say that in his response brief to this court. To this court, beginning on page 31 of his response brief, the argument is hit head on with no holdbacks. If anything, this should demonstrate to this court that summary judgment was not the appropriate way to end this case. There are too many material fact questions that are in dispute, whether we look at it from the perspective of the tax court changing the wording of the form, or look at it from the assessor's records, or look at it from what was actually raised to the Board of Equalization. This case really cries out to go back to the trial court and have these fact issues resolved. Unless, of course, the court would like to rule in favor of Santa Cruz County on our cross motion for summary judgment. But that's basically what I think was important for this court to know in my rebuttal. One last little point. Counsel stated that the county did not submit any affidavits from any assessor employees. We did. There's an affidavit in the record, which we highlight in our brief, from an individual by the name of Miguel Carrillo. And Miguel Carrillo states that the denial of the notice of claim was sent to the taxpayer's address as it appeared on the tax roll.
Didn't counsel say that there was not an affidavit filed on a specific point? Not that there was not an affidavit filed at all from an employee with the assessor's office, but it was more narrow than that, wasn't it?
I have to apologize there and beg the court's indulgence because I was multitasking, and I don't usually have to do that during that pause, and I only heard that part about no affidavit. I wanted the court to be sure to know there was an affidavit. There were no depositions taken. There was no exploration of any underlying facts. I think we all thought the facts were clear enough to speak for themselves, but sometimes you look back and you say, wait a minute, they weren't clear enough to speak for themselves. And given the tax court's addition of wording that doesn't appear anywhere, and then the summary judgment ruling flowing directly from the court's own additional words that it added, the ruling on the motion for summary judgment in favor of the taxpayer clearly needs to be reversed. And whether we go back and find more facts or go back and look at it from the county's perspective and find summary judgment is appropriate in that regard, it does need to go back to the tax court and be resolved there. There's just too many holes in this record for it to stand the way it does, especially when, as this court knows, this is a matter of shifting of tax burdens. These tax dollars don't disappear. They just get shifted. And so, as we've stressed in our briefs, the purpose of the property tax system is really important to be kept in mind when looking through these cases, is that each taxpayer should bear its own fair share of the tax burden so that that burden isn't shifted to anyone else unnecessarily. I think the case that we cited says if that burden is shifted to someone who's not able to protest it, that's not fair, and that's not fulfilling the purpose of the tax system. So here we have a case of a taxpayer who had every opportunity on an annual basis to appeal its valuation under the low-income housing tax credits. It took that opportunity in calendar year 2008 for tax year 2009 and was denied by the assessor. The assessor gave it a reduction for that tax year, but based on market studies, not on low-income housing tax credits. So this taxpayer knew that relief was not available from the assessor and yet chose not to appeal its taxes on an annual basis for the next 3 tax years. Instead, it came back in 2012 and said, oh, the assessor made a mistake. Let's go back for the current tax year plus 3 years. So for 4 years, it wanted windfall tax reductions, which the tax court gave it based on adding words to a form and adding words to a statute. And the Santa Cruz County respectfully requests that that decision be reversed. Thank you.
Thank you, counsel. We appreciate the arguments here this morning and the briefing that was done in this matter. We will take this case under advisement and issue a written decision in due course. We're going to take a brief recess to allow counsel for the next argument to come forward and get set up for that case. Thank you.